Hi, my name is Lauren Fields. I lead the domestic litigation team here at Roth Davies LLC. Today I'm going to be talking to you about the 12 steps of divorce. Step 8. What are status conferences and pretrial conferences in a divorce case? If the spouses are unable to achieve agreements to all the fundamental parts of a divorce, trial preparation comes into play. The subsequent stage in this procedure is reserving and attending a status conference with the court. When settlement negotiations cannot proceed due to the lack of agreements, this meeting will shape the suit going forward and allow the divorce process to progress towards resolution. Nonetheless, it is critical to recall that just because negotiations have fizzled the proceeding at this point does not imply that the spouses will not achieve an understanding before trial. Achieving an agreement regarding the property division, support obligations, and child custody can be done all the way up until the day of trial. If the parties cannot reach agreements on all the necessary aspects of divorce, the case will need to be prepared for trial. However, it is important to remember that just because negotiations have failed prior to this point does not mean that the parties won't reach an agreement before trial. A status conference allows the parties to update the court on what has occurred following the filing of the parties' last appearance in court. The court will learn about any agreements that are in place, as well as any concerns that cannot be agreed upon. For instance, the parties may have reached an agreement regarding property division, but concerns about child custody may remain. The court will consider the issues that remain unresolved and explore the likelihood of an agreement in the future. The court will examine resolution tactics outside of a trial, like mediation. If the court decides on an alternative dispute resolution, it will set dates for the parties to adhere to it. A discovery plan can also be founded at a status conference. This incorporates setting any vital restrictions on discovery, for example, discussing subjects that are deemed outside the scope of the case. Examples of issues that might be outside the scopes of the case may include affairs or relationships post-divorce. In any case, there are exceptions to this rule contingent upon specifics of a case. Due dates for finishing discovery can also be set at a status conference. After this date, any extra disclosure demands from either spouse might be allowed if the parties come to an agreement or by leave of the court. Otherwise, after the due date has passed, neither party will need to answer discovery requests from the opposing side. The last concern to be considered at a status conference is overall scheduling. In addition to setting dates for mediation and discovery, the court will also set a deadline for any motions or amendments. Last, the court will establish a pretrial conference and trial date. To aid in the trial preparation process, these dates are typically unchanged. The purpose of this is to ensure everything is resolved in a timely fashion. However, they are adjusted occasionally at the court's discretion. Status conferences are vital to setting up the course of events for the rest of the litigation, but it does not mean that the court will hold a status conference immediately. Rather, the court allows a period of time for the parties to cool off before the initial status conference is set. This period will be no less than 60 days. However, it is probably going to be longer, relying on how full the court's docket is. Good attorneys can use this period to encourage settlement or assemble data in preparation of a trial. The pretrial conference is often the last hearing held in a case before the final trial. At this point, several attempts at reaching agreements will have been tried, but they have failed. The issues that need to be resolved at a trial will likely have been substantially narrowed, even beyond what they were at the last status conference. The judge will want to know and attempt to address those issues that are still left unresolved in order to understand what they will need to be resolved at trial. This in turn allows the court and the parties to assess how long the final trial will need to be scheduled for. Though it depends on a number of issues left to be resolved, divorce trials generally will not exceed 1 to 2 days absent exigent circumstances. The court will also perform any housekeeping functions to prepare for trial. Any outstanding motions will be addressed, though perhaps not decided. For example, motions in limine, which deal with likely evidentiary issues, may be heard and considered. However, the judge is not likely to make a decision until evidence is actually attempted to be admitted at trial. By reviewing the motions and becoming familiar with the law, the judge can make an informed decision when the dispute does arise, rather than having to shoot from the hip during trial. Any other last-minute issues or problems will also be dealt with at this conference. The goal for both the attorneys and the court at a pretrial conference should be to ensure only the still undecided issues are dealt with at trial. Judges can quickly grow impatient when one side attempts to stir up already decided or non-controversial issues during a pretrial conference. Instead, Experienced counsel can use the pretrial conference to show the judge that he or she has prepared for the matter and are ready to face and resolve only the needed facts. The less fluff left in the case, the more attention the attorneys and the court can give to what really matters in resolving the divorce. The objective for both the lawyers and the court at a pretrial conference is to make sure that only unresolved concerns are presented at trial. Judges can rapidly develop impatience when a party brings up concerns that have already been resolved during this conference. A knowledgeable attorney will use this conference to display his or her preparation for a fast resolution.